Hello guys, thank you for clicking. Most people don't really understand the way probate administration is done in Nigeria. Letters of administration, wills, last will and testament, and all sorts of things that people believe and believe wrongly. And people have gone ahead, based upon this common misconception, they've gone ahead to do some things that they were not supposed to do, perpetrated injustices without knowing it. So in this video today, I want to clear some misconceptions about probate administration, about letters of administration, and about wills. That is what I'm going to do today. Thank you guys for sticking by with me. I didn't upload for the past 2 days because I didn't really understand what was happening with both my phone and my app. I do my videoing with my phone, and somehow it turned out anyway that the phone was full, kind of. That was why. So I had to delete a lot of all my old videos and then back them up. But here we are now. So welcome to Vlogmas. Here's the thing. When people die, let me tell you this. You know there is wills, the last will and testament of Mr. So and so, of your uncle, of who, and then there is letters of administration. Let me try and differentiate between the two. What is the difference between a will and a letter of administration? Because these are instruments that are used after somebody has died. A will, in simple terms, is a document that is said to be the last will and testament of somebody who has died, expressly stating his wishes that he wants to be carried out upon his death. Usually these things contain stuff like instructions for his surviving relatives, if he has an estate, how he wants his estate to be administered, who can collect what, But the thing is that for a will to come to life, that is the operative word for will. A will only comes to life upon the death of the testator. So whoever is the person who wrote that will, as long as that person is alive, a will can never come to life. The only exception to that rule is if the will states that there are particular gifts that will take place inter vivos. Inter vivos means that in the lifetime of the testator, some gifts can take effect. So, for example, somebody can write in a will that I give this my cord to my son, Dele or Musa, and he can take possession of it while I am still alive. That is essentially, in very simple terms, what a will is, okay? A letter of administration, on the other hand, it is a document that is given by the state. Usually, it is in every high court complex, you will find that there's a probate registry. So it is a document that is given by states, granted to somebody who applies for it, and that gives person a right to administer the estate of a deceased person. Usually, a letter of administration is granted where one, somebody has died, and two, that person died without leaving a will. So now let me clear this misconception. Number two, please, and please, when people pass on, when someone goes to the great beyond, all his property, whether the person had a will or not, that person's property falls to the state. Period. Before you can have access to a house or to the court or whatever it is that somebody who has died left behind, you must first approach the state. And the way that you approach the state is different depending on whether you go through a letter of administration or you go through a will. Okay? If this person died and left behind a will, the first thing that will be done is that we will go and check the probate registry. There are ways that you will know that this will is authentic or not. As long as the authenticity of that will has been established, then the beneficiaries of the will, if there's any property, they will now apply to the probate registrar and there are fees to be paid. Okay? So one common mistake that a lot of people have made is thinking that just because there is a will and the will has been authenticated, and in that will your uncle said that he gives you this his house, or he gives you that his car, or this is property, it means it is automatically yours. That is a mistake. Okay? And some people have gone ahead to enter trouble by buying property from somebody whose claim to that land is actually a will. No, when someone dies, his property falls to the state. Okay? You, the beneficiaries, what you need to do is to apply to the probate registrar. Or in some states like Rivers, they don't have probate registrar, they call their administrator general. So it depends on the state. If it's a state that uses probate, it's the same thing actually. Apply, and once that is happened, then for whatever property that you are going to be given, what the probate registrar or administrator general will give you is an assent, and that is what it is, that assent that now grants you title to that property. So if your uncle, a lot of you here are listening to me and you know this kind of thing, your uncle left a house for you, but you never bothered to go to the probate registry to go and regularize your title. You are sitting on a time bomb. Sometimes people will come and say they want to sell property to you. If the person tells you that this property was given to me by my uncle in his will who has passed on, what you need to do is to ask that person for an assent, especially if it is landed property. Ask him for an assent, okay? So you authenticate the will and then ask for an assent, and that is when that person has an assent in his will, that is when you know that that property belongs to him, okay? But if Musa or Adamu or whoever passes on and his property is in a will, unless there's an assent, that property falls to the state. I hope I have cleared that. When it comes to letters of administration, the misconceptions are very, very different. What a lot of you believe and erroneously believe is that when somebody is granted a letter of administration, it operates the same as a will, and it means that every property that that person owns belongs to you. Mr., Sir, Auntie, no. That is not the way the law works. If a letter of administration is granted to you, sorry, no, this one in my head is me. If letters of administration are granted to you, it means that the state grants unto you the right to administer the person's interest, and there are laws regarding how you are going to administer those interests. You are obligated to do it in the best interest of the estate, not in your own interest. You are obligated to take care of all his assets and his liabilities. So if the person had liabilities, like he had taken out a loan or something like that, you as the administrator of the estate, you are obligated to pay off those loans. If he had dependents, then you are obligated to look after the dependents, and as much as possible, you will execute it following the wishes and interests of the deceased person if those wishes are known. Letter of administration does not mean that you have been given all the property. A lot of people have perpetrated injustice without knowing it, because somebody would go on to the great beyond. He has small children, and just because he died without a will, you will pack all his property as the uncle who was granted letter of administration, and you say, no, it was given to me. No. As an administrator of the estate of a deceased person, you are accountable to the administrator general or probate registrar of every state. You will give account for everything that you did with every kobo or everything at all that was in that person's estate. It is not for you. I hope you understand. And then the last thing that I want to talk about again has to do with married people. Yes, it is true that when you are married under the act, and that's one of the reasons why we keep telling women, try as much as possible to marry under the act. If you are married under the act, automatically, even if your spouse dies without a will, you automatically become his not next of kin now. You automatically become the administrator of his estate. Okay? Letters of administration will be granted to the surviving spouse before any other person. But again, that does not mean that you collect everything in the estate and say it is your own. Okay? A lot of people think that, a lot of women now, the misconception that women have is thinking that because I have married the man in court, I can just cross my leg and sit down. No, it does not mean you should cross your leg and sit down. If the best claim that somebody can have to the estate, the best preparation somebody can have for going to the great beyond is a will. In the absence of a will, then a letter of administration. So you, if you are a woman and you are married to a man, don't think because you have married him under the act, it means that when he dies, automatically everything belongs to you. No. Whatever it is that you do in the name of the estate of a deceased person, you are going to be accountable to the probate registrar. That is the bulk of what I have today. I don't really want our videos to be too long. Thank you so much for clicking. I really appreciate that you stayed with me up till now, and I'm sure it probably means because you enjoy the sound of my voice. I made a lot of sense, and of course it's Christmas and you want to spend time with me. I appreciate that. I would also like you to click on the red button there that says subscribe. Thank you very much, all my new subscribers, all of you who keep coming back. Leave me a comment because that's going to help with the algorithm. Let me know how it is practiced. And again, if you have any clarification that you would need clarification, there is a link in the description box. Click on that link. It's gonna give you access to my WhatsApp after you paid for the consultation, to give you access to my WhatsApp, and I'll clear any other legal issues that you have pertaining this topic or any other topic at all. For those of you who have been coming to my email, I have one happy new year like that for you guys. We are going to enjoy ourselves in this new year. So if you are already my subscriber, subscribe. Thank you very much. I'll see you all in my next video. Bye.